Professor Godard, dear colleagues. So I'm Ekkehard Heinze from Germany in the German IP law firm of Meissner Bolte, based in Munich but having branches throughout Germany. I mainly dealt with patent and trademark work in Europe, as a matter of fact. So Europe is our region. I am a physicist, and after my studies I worked for some years as a scientist. Later on I became an in-house counsel in a big scientific body, and then for, well, quite a number of years I'm a patent attorney, patent and trademark attorney. So my issue will be, or my speech will be, on recent U-turns by the EPO, which means greater safety in patent protection in Europe. And the overview is as follows. First issue will be the question whether multiple independent claims can be used in Europe, what means before the EPO. And under this issue we have a first important new aspect of European practice, which means more value for PCTs in Europe. Second issue is the EPO search schedule and the problem of non-searched subject matter in Europe. Third issue is the European search report or European search opinion, respectively, and the course of substantive examination before the EPO. Fourth issue is divisionals, well, as a last exit on the one hand and as a tool for obtaining improved claims on the other hand. Here we have another important new aspect, namely that the timely restraints for divisionals in Europe will disappear. Fifth issue is these important U-turns of the EPO provided again as a summary. And sixth issue is some conclusions for filing in Europe. So, first issue, multiple independent claims in European patent applications. Basically, yes, as long as they are related to a single invention or a single group of inventions. If, however, the application lacks unity, what means there are more than one invention in the application, you should either be prepared to pay additional search fees to obtain a complete search, and finally should be prepared to file divisionals on these other inventions in the first existing application, or you should be ready to focus on just part of the original claims and, well, refrain from further prosecuting the remaining claims. Please note, lack of unity can not only occur from the first beginning of the draft of the claims, it can also be the result of a comparison with the prior art, so it's possible to have a a posteriori lack of unity objection. The possible options are the same as with the ab initio lack of unity. All in all, we can state that with regard to this issue, there are some similarities with the USPTO restriction requirements. But in some regard, the EPO is even more liberal than the USPTO, namely with admitting device and method claims in one application. The second, part of this issue, multiple independent claims in the EPO, is even if there is one invention, problems can arise with multiple claims in the same claim category, whereas, as I told you, method plus device claims are typically no problem. It may well be a problem to have several independent method claims or several independent device claims. And typically, such plural independent claims of one category will not be admitted, will not be allowed. There are certain exceptions defined in the European Patent Convention, namely if there are different but interrelated products which are covered by the invention, then you can use several independent product claims, or if different uses of a product or apparatus are to be covered, it may be possible to use several independent method claims, and likewise several independent claims may be admissible for alternative solutions for which a single claim is not appropriate. So you see, basically you have to argue against an objection regarding several independent claims, or if possible you can transform some of your several independent claims into dependent claims, which might in particular be appropriate when you have a US-style claim set where in plural independent claims the same or very similar features occur. Specifics with PCTs filed in the EPO. You may be aware that the problem of an incomplete PCT search due to an alleged lack of unity can today only be resolved in the international phase, namely by paying additional search fees in the international phase. There is no way, at present, there is no way that the EPO searches and grants claims which were not searched in the international stage. In this existing application, you would have to file a divisional in such case. But from November 1st on this year, the first option will still exist, but a second option will be added, namely that you pay to the EPO in the European regional stage additional search fees within a due term, and this will be valid for already pending EPs as long as first office action or the supplementary European search report has not been issued. So what about the EPO, the strange EPO search approach? You may know that it is different from the approach of most other patent offices worldwide. The EPO regularly searches at the beginning of the whole procedure only. The issuance of the European search report typically and regularly terminates the search activities. This has to be understood before the historical background of the foundation of the EPO. They had basically a search part or a search division and an examining division. And once the case went from the one division to the other, there was no way back to the search. So typically, even as to amended claims, no additional search will be made, which is quite different from the practice of other patent offices. But you have to take care for this, and there are some difficulties which may arise from this. In particular, you will face difficulties if you wish to include features from claims which were not originally searched into claims which have to be amended due to, well, lack of novelty or lack of an inventive step. I will not go into further details at this stage. So what to do with the EPO search results? What comes after search? Basically, if you have a complete search, the search report is being issued, and it is of the type of a first substantive office action. If the search is incomplete due to lack of unity, you know what has to be done from my slide before. If there is an incomplete search for other reasons, for example, for lack of technical character of the invention, basically you can only argue to obtain a complete search, or the whole thing may be finished. In any case, start the substantive examination